My name is Ron Palmer. I'm a father. I'm also co-owner of Fixed Family Courts, and I'm here to support the bill. The main reason I support the bill is because it is a good first step in getting us to a constitutionally compliant family code system. We are very, very far from that today. I want to start by quoting the Bible, and I'm not the kind of person that often quotes the Bible, but one of the judges earlier, one of your witnesses, quoted the Bible, and it struck me. And he said, "Fear not the court if you haven't done anything wrong." Now I'm here to tell you I'm terrified of the court, and I'm terrified of my judge for no other reason than that I got divorced. I didn't choose to get divorced. I didn't want it. I was served with divorce papers. I had to show up and defend myself. My rights were stripped based on the filing of a petition. What I found, what I knew then but couldn't prove, and what I've since proved in the books before you, is that parental rights are fundamental liberty interest. They are protected in the First Amendment, freedom of association, freedom of family association, that almost all of the federal courts have ruled on, the appellate courts have ruled on, and they have been unanimous and absolutely clear that these are fundamental rights protected at strict scrutiny. These are also Fourth Amendment rights, because a divorce court order, a custody order, is a seizure order. Your child is being seized from you in violation of the Fourth Amendment if it's not a reasonable seizure. Anything less than 50-50 is a seizure that is unreasonable. It's also a 14th Amendment right under the Liberty Clause. You have the right, so the Supreme Court says, to the care, custody, and control of your child. This is a privacy right. Privacy rights are protected at strict scrutiny. Our own governor, when he was Attorney General, put out an opinion as Attorney General that says these are fundamental rights, that said parents must be presumed to be fit and to be acting in the best interest of their children. It doesn't say except for divorce. It says they must be presumed, right? And he goes further to say this is protected in Texas at strict scrutiny. He's in agreement with Justice Thomas, who said in Troxel that this should be governed at strict scrutiny. And what that means is that the state must have a compelling interest to intervene. Not only that, it must be necessary to intervene. And I'm here to tell you it is not necessary for a divorce court judge to wipe out all of your rights and deprive you of due process simply because you got divorced. Now here's an interesting thing. It used to be that parental rights depended on divorce or depended on marriage. We had these things called bastardy laws, right? Back in the 70s. Some of you people are old enough like me, you remember these things, right? Your rights as a parent depended on whether or not you were married when you conceived that child. The Supreme Court said that is unconstitutional. You cannot create two classes of parent or two classes of child based on the marital status of the parents. They also said in Stanley versus Illinois and Caban versus Muhammad and numerous other cases that parental rights are individual. They do not depend on the marriage or your marital status or whether you've ever been married. They are individual. They are shared between a parent and a child. Right? Now what that means is that divorce cannot possibly be a reason, a necessity to deprive a parent of their rights. Can't possibly be. These are natural rights. These come to us by God and nature, not by the state of Texas. The state of Texas never granted me my parental rights. They tried to deprive me of my parental rights. I fought and got equal custody of my child. I have every other day and every other weekend with my child. It works. She excels at school. She's a great child. This works. And it's upon the state to prove that it doesn't work before they can do anything else. That's called the least restrictive means test. It's part of strict scrutiny.
I'm sorry, we are on a time schedule here. We'll never get out of here if we don't. So if you could please kind of wrap it up for us.
I can answer a lot of the questions that have been raised here. All right, for instance, whether or not it works, it absolutely works, and the burden of proving it doesn't work is absolutely on the state. Other Supreme Courts have found this. The Supreme Court of Wisconsin just recently ruled unconstitutional a whole big portion of its family law code based on the same arguments that we put forth in the book. Chapter 18 will address many of your questions about what this would look like if we actually decided to be constitutionally compliant.
Well, I think you gave us some books here, and I think I, for one, will look at them and read them, and we really do appreciate your testimony. Members?
And one
Yes,
last thing I'd like to say, if I may, is that we actually have a word for this idea of the best interest of the child, and that a judge can decide your family structure and what your family looks like, and it's called socialism. And that's not supposed to exist in Texas, of all places.
Representative Hughes?
Thanks, ma'am. Let me ask you a couple of things. So you said you've got, in your case, you've been able to get to 50%. Tell us how you did that, if you can.
I did not use the law at all. All right,
So
because
y'all-
if I had to go to court, there's no way I would have got that.
So you and your ex-wife worked it out where you could do the.
Well, I used strategy, I used expense, I used everything I've learned in all of my years consulting in some of the largest companies about how to do strategy and how to work this and how to do negotiations, and I paid through the nose.
One more question along those lines. There's been a lot of questions and testimony about school, and you mentioned y'all do every other day, every other weekend.
Right.
How's that work with school? Tell us where y'all live, where the school is. Tell us how that works, because that's what the committee needs to understand, what this looks like.
Right. We live in Corinth, Texas, which is just north of Dallas, just south of Denton, very small town. The family code allows for what's called a geographic restriction. My wife can move anywhere she wants. I can move anywhere I want. My child has a geographic restriction to basically the small city where we live. Right? That geographic restriction is commonly in the county or neighboring counties. We tied it down to the school district, essentially, so that our child goes to this school. Either one of us can move as far away as we want, but that child has to go to that school. If you can move 100 miles away and arrange it, then so be it. You make that decision. If you get somebody else to get your child there, whatever, as long as you do what you're supposed to do. But that geographic restriction works. We set out the school schedule all the way through till my child's 18 in the order. And that is one of the small things, under strict scrutiny, that a judge has a legitimate interest in resolving, because there can only be one school, unless you go with an online route, which Texas has an online route, so that children can go to school online and can live far apart, and equal custody absolutely will work.
Thank you.
But under strict scrutiny, a judge can decide a single school that the child will live in and provide for a geographic restriction and be constitutionally compliant.
Okay. Thank you very much. Thanks, Madam Chair.
Thank you very much.
Thank you.
Chair calls Frank